Good morning, Mr. Law. Good morning, Ms. van der Heever. Good morning, Mr. Matlala.
Good morning, Chairperson. Good morning, Commissioner.
Please pull the mics closer to you and switch both of them on.
Morning, Chair, and morning, Commissioners.
I greeted you and your mic was off. Good morning.
Good morning once again, Commissioner.
Thank you.
Thank you, Chair. Chair, Commissioners, you'll recall that Mr. Matlala had been subpoenaed to appear on the 7th of July, 2026. And on that date, Mr. Matlala's legal representative and I presented ourselves before you, and we had an engagement, the outcome of which was that Mr. Matlala's appearance was postponed to the 15th of July. Today, and the commissioners issued a ruling in that regard and on some other aspects. Mr. Matlala is present. We are back before you, and Mr. Matlala's legal representatives would like to address you, Chair. The issue about which she is about to address you is contained in the folders that have been made available to you, but I will leave it to her to take the commissioners through the contents of that folder. Thank you.
Ms. van der Heever.
Good morning, Chairperson, Commissioners. We have prepared for your benefit and in support of our application for a postponement an affidavit that was duly deposed to by our client. Due to time constraints, however, we were only able to last night email an unsigned copy to my learned friend. The situation was that for a variety of reasons this could not be done earlier. I would like to very briefly, if it's necessary, Chairperson, Commissioners, just take you through our reasoning as to why we respectfully submit that a postponement in this matter should be granted.
Is there a signed affidavit now?
There's indeed a signed. It was commissioned this morning, and we thank the commissions, my learned friend and her team, for assisting us with that. Even at, I think, at 10 o'clock, there was another endeavor made to get it signed at the prison. There were some arrangements, but it just came to no fruition.
I do see it in a small folder in front of me. I read from my laptop, and that was an unsigned version. Thank you, thank you.
Chairperson, in short, we set out the history of what's transpired vis-a-vis Mr. Matlala, when he was arrested, how the events surrounding him has unfolded. And the most important aspect thereof is the fact that he's due to commence with a trial on Monday. We believe that he's got the constitutional right to attend this trial and be regarded as innocent until proven guilty, together with the other constitutional rights that we've dealt with in this particular affidavit. We respectfully submit that for him to deal with some of the issues, which issues play a very big part in the up-and-coming trial that starts in 4 days, would violate his constitutional right to actually challenge the evidence. We've indicated to you, for instance, that both witness C and Lieutenant General Nkomazi relied on a statement that was given to them by Mr. Matlala.
Before you get to that point, let me ask a general question. Is the submission that a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings.
May I please, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my
You see,
client...
I'm raising the point that that was a minority judgment to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder.
Yeah.
I did not say anything.
No. I think respectfully, what I've endeavored to show to you...
You know what we always say in the legal profession, both amongst legal practitioners and people presiding, that when counsel says respectfully, they actually mean the opposite.
I was told that many years ago by a good friend that presided over a trial where he said, that was the impression. But I
sorry for interrupting you. I'm sorry. Yes, please.
I fully understand.
Yes.
The point is that is the nearest that we could come to any authority on this point. And this issue to us was so important that we were going to try and see if we could actually deal with this matter, if necessary, elsewhere. Where we are right now, I respectfully submit we don't have to go there.
Where is elsewhere? Is it a court application?
Yes. No, only the approach would have been to actually make, if the matter were to continue, to make the necessary full-blown legal argument and submissions to you, and then depending on your findings to take it on review. I'm honest, I've indicated that to my learned friend before too. It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty bound to come and do at the commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc. And for that reason, we will, at the end, of course, also assist the Commission in finding the truth in this, what I respectfully say is a quagmire of facts that you have to deal with. That is the one issue.
Or may I, before you go to the next issue,
I think I've made that quite clear when I discussed with my learned friend. The difficulties that we find ourselves in at this point in time. And that was also the issue that prevented us from actually dealing with any affidavit beforehand, is that our client And I was not party to that particular agreement. I only came in later through a different legal representative with IDAC. The gentleman that's been named here was part of that, entered into to a 105A plea agreement. The magistrate then came back and found that the sentence wasn't just and therefore gave all the parties time to go and reconsider. The issue that's when I got briefed to come back in, because there were very material and important issues that were not raised in the 105A that we believe would have materially influenced potentially the outcome of such an agreement. The only time that matter could be dealt with, or the issues that was raised at that point, and if you bear with me, I have to choose my words carefully at this point because it's a very difficult situation, was when the magistrate finally made a ruling. So past Monday, that is 2 days ago, he actually, in terms, I think it's a 105 capital A 9B Roman 2, if I'm correct. He actually said, well, he asked the state, what is your contention? The state said, oh, we wish to continue. He asked us and we said, no, we assailed from the agreement. What then happens in terms of the Criminal Procedure Act is that it's as if there was never any plea negotiations happened. The issue for me is, and this is where I want to answer your question, Chairperson, is we were not involved in those negotiations. We know what transpired and under what circumstances in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what's happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client that these are questions that you have to answer, you're compelled to answer them. You can't, let's say, invoke Section 35 rights. And as we sit here, Chairperson, we still can't give you an answer to that question because we still don't have that. So there is, of course, and that is the long and the short of it, there is answers that you can answer. But at this point, I can't come to you as an officer of the court in honesty and say to you, okay, this is my instructions. I need to, because of this quagmire of IDAC's involvement, be sure that what we say to you is truthful, because there's also the penalty of perjury, and of course there's a previous inconsistent statement that can be raised at any stage. So for that reason alone, I agree with you. There are issues, of course, you can never assail your compulsion to answer to those. But until such time as we can present to this Honourable Commission an affidavit that we satisfied contains is based on facts and where we can invoke that right correctly, I cannot even go as far as to say we don't know this person. For instance, I could have come to you now because I know from the list, Annexure A, we could give you a list and say we don't know these people. But for the rest, it's not in your interest that we present in your, and I mean the Commission, the Royal U, interest that we present in piecemeal fashion answers to questions. The fact of the matter is that my client has been made out to be this mastermind by everybody. And we respectfully, from our interaction, say that there's a fallacy in that. And we intend to show.
Please tell me when you are done with responding to my question.
Yeah. So,
before you move on to another
I've
point.
basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then asked you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level, just...
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues, why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing and I need to understand in those negotiations who, what and where. And without that, I cannot,
Are you talking negotiations relating to the plea deal?
Relating to the plea.
That's history now. I'm asking you about now, please.
It's not history because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not committed to.
Is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about. I'm asking you about the precedence.
Yes,
Which of the two processes must precede the other? So I understood you to be referring to the plea deal. In the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end. That's something else altogether.
No, that's not.
It has nothing to do with whether, once the plea deal is dead and buried, must the commission process wait for the criminal process. So the earlier issue, the plea deal, is finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain.
All right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for
purpose
what
of
purpose?
invoking my right to silence on that. I can say,
No,
I've been
then you
told,
don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that post the plea deal may also fall under the section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside and let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
let me again try and explain to you, Commissioner or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying I'm not interested in the nitty-gritty of what falls under the section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the section 35 basket. Even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to the next point.
No, I do understand you quite clearly. The only issues that my client can answer, Chairperson, at this point that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please, the rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if
I have not asked you that. You are trying to answer a question which I've not asked you. I've not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is on those issues on which there is no question whatsoever. Those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the section 35 basket on those issues. And again, I repeat, this is a general question. On those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process, what would the basis of not doing so be?
the only basis with